So I think that all intents and purposes, that act is dead. And we're going to have to go back to the well and recognize what's been poisoned and come up with a cleaner version. But it's going to be a fight. I think it's going to get darker before it gets lighter, unfortunately.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon. Before listening to him, please ensure to smash the like button and subscribe to the channel.
Well, where we're at right now, Ash, is exactly what you just said. I was listening in on your conversation, and you said, what is intervention too much? What is intervention not enough? And that's where we're at. And unfortunately, in the United States, we don't have regulators and politicians who necessarily lead in the first place. They react, and they always react to a crisis. And there's a danger when you react to a crisis, you go from not enough regulation to over-regulation. And that's the danger zone that I basically think you summed up just now. And so my fear, I think about this, right when the FTS, what I believe is fraud, was exposed, what did the regulators do? You had two U.S. senators who had worked with Sam Bankman-Fried who wanted to offer the DCCPA up immediately. So why would your immediate reaction to the FTX collapse be to propose on the floor of the U.S. Senate the bill that he was sponsoring, which of course a lot of people believed attacked DeFi and gave advantages that he was seeking. So that's the danger that we're at right now as far as regulation. And unfortunately, I think we're going to continue to see what we've been seeing for the last 4 or 5 years, which is regulation by enforcement actions. And the SEC has focused on all these non-fraud cases that we can talk about, while all the fraud type cases are going on underneath their nose. Well, I think that just like everything else, Ash, it's the devil's in the details. And when you get into the details of that bill, there were problems with definitions and whether or not how can you take a regulatory scheme that is built, basically a securities case, if you're not talking about fraud, it all comes down to disclosures. Well, how do you impose certain types of disclosure on decentralized entities, for example? Right. And so that's where the focus was. So I think that all intents and purposes, that act is dead. And we're going to have to go back to the well and recognize what's been poisoned and come up with a cleaner version. But it's going to be a fight. I think it's going to get darker before it gets lighter, unfortunately.
What's happening with Ripple? Give us a little bit of context for those who may not be following the story, what that case is about, and the broader context why it's so important.
Sure. Basically, the SEC is claiming that XRP, the token that is associated with Ripple, that it is a security and that it's always been a security from the beginning of time. And if you read the complaint, going into the future. And I got involved, Ash, when I first, as an XRP holder, and for your audience to know, I have a higher investment in Bitcoin, much higher than XRP. I have a higher investment in Ethereum than I do XRP. But I got involved because when I read the complaint, I noticed that they weren't limiting the charges to when the Ripple company or its executives sold during these early years when the ecosystem was much younger and there was less activity on the XRP ledger. That's what I expected. And instead, they went and said, even though we've allowed it to be traded for 7.5 years, even though the Government Accountability Office recognized it as a virtual currency in 2014 on a decentralized payment system, and although FinCEN in 2015 said it was virtual currency, we're going to go back retroactively from the beginning of the time, 2013, and say all sales, including secondary market sales, that the token security. What that meant for XRP holders was that whether you have it in a cold store wallet or whether you have it on Coinbase or any other exchange, what you own is an illegal security. And that's something that's never been done. Securities law has never been basically saying that secondary market sales independent of a promoter or company were also securities. So I got involved, and I actually have 76,000 XRP holders from around the world. There's 143 countries, including the United States, who have joined together, and we went after the SEC, and the judge granted me to be amicus counsel on behalf of the SEC long before Coinbase and everyone else got involved, and we filed a brief. But
amicus counsel, of course, for folks who may not know, is a friend of the court brief that you're able to file on behalf of the broader sort of context of the industry to support customers and others.
Basically, and my whole focus, so your audience knows, was not Ripple. You know, they have high-priced lawyers that can deal with them. It was the token holder, it was secondary market sales. Because, guys, if the SEC is successful and they're able to say the token itself, which is really just alphanumeric code, it's software code, that token itself, no matter who owns it, is a security that has massive implications, not just for XRP holders, because you could take that analysis and apply it to even Ethereum. You know, I know a lot of, and I'm an ETH owner, so, you know, nobody attacked me, right? I own more ETH than I do XRP, man, make it clear again. But the problem is you have senators, you have the SEC chair, Gary Gensler, now backtracking and saying, well, we only think Bitcoin's a commodity. So if XRP was deemed a security, the same analysis then could be applied to Cardano and to XLM and to ETH and all the other altcoins. And so there's huge implications by this case. And I think the misnomer that a lot of people have been operating on for a couple of years is that it's just an XRP story. It's just a Ripple story. Right. And it's not, because we've had Coinbase along with other entities file amicus briefs as well.
Talk a little bit about Ethereum and how it may or may not be construed to be a security in the framework of the XRP conversation.
Oh, great. Now, I've made on a record to say that if XRP is deemed a security, then ETH is no doubt. And here's the reason. Everyone knows that Ethereum held an initial coin offering, an ICO. It was a traditional pure ICO where you take crowdfund and you take that money and you build the blockchain. And so that is the definition of an investment contract, AKA a security, where you invest your money, you're relying on these promoters, and you're expecting the profits to increase, and you're investing in the common enterprise of the Ethereum developers, the Ethereum Foundation. So there's no credible argument that it didn't start off as a security. And XRP holders disagree with me when I say the SEC could win this case if they limited it to initial 2013 sales and when the ecosystem was just starting. What a lot of viewers need to understand, Ash, is that the SEC in 2015, when there were only a few Bitcoin miners who concentrated the real core, the mining, over 50% of the mining, the SEC was claiming Bitcoin was a security because that was the common enterprise, the Bitcoin mining community, and you're waiting for expectation of profit to go up. So you got to understand, when you're taking 1930s law, right, long before any idea of blockchain technology, and you're taking a Supreme Court decision from 1946, the Howey case, which dealt around oranges and orange groves and agricultural processing. When you take that and you try to apply it to modern day blockchain technology, as you can imagine, it's not an easy fit, right? You're trying to put a square peg in a round hole, and that's where we're at. And unfortunately, we've had no guidance. But a lot of people believe that ETH, because of the Hinman speech in 2018, when he said, listen, present day sales of 2018, Ethereum's not a security. A lot of people believe that that was a regulatory free pass. But that's just one person at the SEC who's no longer there. And the real issue today is, why isn't Gary Gensler comfortable saying Ethereum's a commodity? I believe it's a commodity, right? Let me make that clear. And why is Senator Loomis, who was saying Bitcoin and ETH were commodities, now publicly say that maybe only Bitcoin's a commodity? Because they're saying that the merge, because it becomes more centralized and you have, you know, the more stakeholders that have more authority and say over the platform, therefore it's become more centralized and less decentralized over time. And so ETH, really, if you're an ETH holder like I am, you should be concerned in this Ripple case, because as you can imagine, if the SEC were to get a total victory, they could turn around and make those arguments. For example, Ripple didn't have an ICO. They went through venture funding. right? And so there's certain things where ETH, certainly in its beginning, were more of a security than XRP. Even though ETH holders would argue that XRP didn't become as decentralized. XRP holders believe it's more decentralized. We're not going to get into that debate, but the point is, for our conversation, is there's a lot on the line with this Ripple case, because do people really believe that in the next year that we're going to get legislation that is passed by the Senate, passed by the House, and signed by the President of the United States, where it gives clarity to the market? I'm not an optimist in that area, which means that this decision in the Ripple case could give us basically the de facto regulation. If this case goes to summary judgment, there's a good chance that both sides will appeal. Even if it's a split decision where the judge says these early sales were offers of unregistered securities, but today's token is not. If that were to happen, you could have the SEC appealing part or Ripple appealing part. So when you look at the Ripple brief, I described it as an appellate-ready brief. It's written for the appellate courts. And so if there is not a settlement, I see this case going on to the Second Circuit and possibly further. And listen, earlier we were talking about this 1946 Howey's case. There has not been a case to apply this kind of technology. So a lot of people think we could get a Ripple test, 5 years from now from the U.S. Supreme Court.
If summary judgment ruling is in Ripple's favor and the SEC appeals, would XRP still be okay to relist on U.S. exchanges during the appeal process?
Yes, that's going to be an individual call by each exchange. When you get the clarity of a judge saying the SEC is wrong, that's going to give a lot more confidence for exchanges such as Coinbase or Kraken to then have the confidence that they have now some kind of clarity where they're not at risk of being being sued for selling XRP. They give them cover. That's an individual decision that they would have to make them, but they could, because the judge is very aware. She granted us amicus status. She knows that there's tens of thousands of holders. There's been 17 amicus briefs filed in this case. So it's very possible, but you have millions of pages of documents have been filed. And so she's going to go through it. I would say the end of March is the earliest. I fear it could go into April or early May for a decision as well.
What does John think the importance of the library case and the insider trading case involving Coinbase employees is to the definition of a security?
That's a great question. You got some really smart viewers. That's a great question. The library case was overlooked because, it's only a $250,000 raise, guys, in a non-fraud case. And the SEC was saying that this library credit was being used as speculative investment. How many people do you know out there speculating on the library credit? Most people didn't ever heard of it, even professional traders. And so the judge's decision there is vague on secondary markets, and it's something that may later be addressed. And so that decision is being used by the SEC to try to convince the judge in the Ripple case that she should find similar. Now, the Coinbase is interesting because the SEC sued individuals claiming that there were these 9 tokens were unregistered securities, but they did not sue Coinbase. So I just want your viewers to think about that. So according to the SEC, these 9 tokens, many are ER20 tokens, that they are unregistered securities, but they're continuing the listing by the largest crypto exchange in the United States to sell them. Why? And I believe it's because they don't want to face Coinbase's legal team right now, which would be similar to the Ripple legal team, and these individuals where they can get some kind of agreement, precedent ruling. It would be called dicta. It doesn't have like binding authority, but it would give them more ammunition. Hey, these guys sold unregistered securities. They admitted to it. Here is a consent judgment, and it's just another feather in the SEC's cap as it launches forward more against other crypto companies, including maybe Coinbase down the road. Today's XRP and future sales are not securities. That's going to be clarity for XRP holders. That's going to give some exchanges the confidence to relist, and XRP goes on. It would also give Ripple's businesses in the United States who are waiting for that clarity to possibly join in. But the SEC could certainly appeal that decision. Will they? No one knows, but it would allow the SEC to then come back and claim, even if they lose against Ripple, they could say, well, that was Ripple's story. This is a different XLM story. This is an algo story or NETH story, whatever. And different facts, different circumstances, and we're still moving forward. So both the case could move forward and appeal, and the SEC's regulation by enforcement could continue.
Yeah, final question. I should say, before we read this question, spectacular questions here. These sound like maybe institutional investors, maybe securities lawyers who are watching this conversation. Just absolutely fantastic questions. Thank you for them, guys. And this final question comes to us from Prosperity Fund, sounds like an investor, on YouTube, asking a follow-up. Could the judge punt to the jury? Outstanding question. Just so your viewers know, right now, each side, the SEC and Ripple, are saying to the judge that there are no facts for a jury to decide. Here's our version of indisputable facts. Here's theirs. For example, whether or not XRP has utility and people own it, not for investment, that first prong of Howie, but they use it to send money on the XRP ledger overseas, or they're using it for other reasons, right? The judge could say that non-investment use of XRP is a fact that needs to be decided by a jury. So I'm going to reserve my ruling, and we need a jury trial on certain issues. That is a great question, and that could happen. A lot of people think it's unlikely. I don't think it's as unlikely as some lawyers think.